How's everybody doing today?
Doing well.
Good. I'm glad to hear that. So I just finished a webinar for AGLA on understanding the terms of your written rental agreement. And I know that you guys all learned that last month. So yay. Want to touch on a few things today. Have been getting quite a few questions in regards to the money and things along those lines. Just so you guys know, the tenant does have to apply. Here's my theory on that. It's going to wipe their slate clean. They're not going to owe anything. So why they wouldn't want to apply floors me. So be careful in your approach and how you approach them, because that's going to feed how this is going to go. If you approach them and you're like, roar, that's going to cause quite a bit of a problem. So you want to be extremely cautious on how you approach your tenant to get them to apply, but let them know, hey, if you apply for this, it's going to wipe out your rent and you're not going to owe anything. So that helps tremendously when trying to chat with them about that type of thing. So definitely want to get to all your questions today. I know I've had a few weird ones come about. I'm starting to get a lot more questions in regards to emotional support animals again. You guys think of it as a wheelchair. Are they allowed to have it in their property? Absolutely. Can you have any additional rules? No. Can you have any additional deposits or monies they have to pay? No. It's just like a wheelchair. Emotional support animal works the same way. And if you think about it as an emotional support animal, as being a wheelchair, you'll most likely answer a lot of your questions. Can we charge an additional deposit? No. Can we charge additional rents? No. Can we have special rules? No. I mean, these are all things that make sense when you just put it in perspective of it's not a dog, it's not a horse, it's not a rabbit, it's a wheelchair. And when you look at it that way, you'll probably answer a lot of your own questions so that it all makes sense, okay? I'm letting people in here. I don't know if I still have my lovely web guy helping, but I'm trying. There is no proof to prove that it's an emotional support animal, and watch how quickly I say this, okay? Like a peacock or a pig. Here's the problem. If you're in a city and farm animals aren't allowed in the city, then they wouldn't be able to have a pig. It's going to have to do with your municipality and what animal control says. Okay. So as long as it's okay with fish and game, federal wildlife, and things of that nature, you're most likely going to have to allow the animal into the property. The animal cannot be a nuisance. It cannot sit there and bark all day. That would be a nuisance. Think about it as a wheelchair. If somebody put sirens on that wheelchair, so every time it rolled through the community, all these bells and whistles were going off, that would be a nuisance. It would be affecting the right of quiet enjoyment for neighboring residents. So can't do that. We'd have to tell them to exchange the wheelchair for one that wasn't a nuisance. Same thing with a barking dog. We can't tell them they can't have it. We can tell them they can exchange it for one that isn't a nuisance to the community. Same thing applies to a caregiver, you guys. Just saying. So if you have somebody that is disabled or something along those lines, and they have a caregiver that is a nuisance and annoying to the community, you can tell them they need to exchange it for a caregiver that isn't a nuisance to the community. So that's kind of how you work that one in there, okay? Hold on, I thought I saw a question come through. Can I mandate my tenants to get renter's insurance with 30-day addendum after COVID ends? It's going to depend on what city you're in. Okay, how about a daycare and a rental, deposit or extra rent? Let's talk about this. Daycares and rentals. Technically, per fair housing, you have to allow them to have a daycare in a property. I always say you're running a business in a residential dwelling and it's not allowed. So when it comes to a daycare, you definitely want to talk to your legal counsel because they know the judge in the courthouse that you're going to have to go to trial in. So they know how it's going to work out in a courtroom. So they're the ones that need to advise you on the best approach because it's going to depend on who governs you, what city, what court you're being heard in, etc. So when it comes to that type of thing, make sure that your legal counsel is on board because we need them to tell us about what's going on there. And the reason that I'm telling you guys to wait till January 1st to make changes and things like that has to do with the 2 pages of retaliatory issues they put in Senate Bill 91. Okay. If you want to make sure you are completely avoiding any kind of lawsuit, retaliatory issue, and I mean completely avoid, no question, can't do anything about it, can't even open that door, I would wait till 6 months after the pandemic has ended, which in this case, if it ends on June 30th, as everything appears to be, because there's light at the end of the tunnel, I think that we're going to open back up and everything's going to go back to normal starting on July 1st. If a tenant contacts fair housing or code enforcement, we can't touch them for 6 months or it's considered retaliatory. What do you think a global pandemic's going to do? Are we going to be able to turn around and increase rents on July 1st? Are we going to be able to tell the tenant they got to get out with no reason? I have a feeling that we're going to have to wait 6 months in order to be completely protected for retaliation before we do anything like terminating tenancy, increasing rents. And this I have to say to you guys, and please hear what I'm telling you, okay? The state of California is 78% tenant occupied. We, as landlords and housing providers, are the minority. 78%, 3/4 of the vote is a tenant. Okay? Now that I said that, please take note that 50% of all tenants in the state of California are behind in rent because of COVID. 50%. In case you guys aren't paying attention, half of the state is delinquent in their rent right now. They're determining that about 15% of that actually has a genuine need. And the other ones are exercising their right. If they're just exercising their right and they really don't have a need, don't poke them. They're ready for war. Okay, it's me talking to you. If you have a tenant that has paid you on time throughout the 16 months of the pandemic and they haven't been late and they've been paying you on time, here becomes my next question. You're in a big hurry to raise their rent. Why is that how you're going to thank them for paying their rent through a pandemic? Is that going to keep the balance right? Is that how you are going to reward them for paying you throughout the pandemic? All I'm asking you to do is think about it before you're in a big hurry to increase rents. If they've paid you through this entire time, it's not a very good business practice. Just saying. Let that sink in for a minute, okay? Because what if that was you? What if you were the one paying that every month? And then for a reward, when it was all said and done with, instead of your landlord having to do an eviction or do anything, they don't have to do any of that because you paid your rent and they reward you by increasing your rent. I'm just saying, I would wait at least 6 months. It's the best business practice not to do anything until January 1st of 2022. Absolute best business practice, safest practice, also ethical. Okay, we don't want to reward them for paying their rent by increasing it. It just doesn't make sense. Patty, when we make repairs in a unit with a comfort pet, can I require that the resident be present to watch the pet so it won't get out of the apartment? Absolutely. Whether it's an emotional support animal or it's not an emotional support animal, you don't want to let their pet out of a property. You could ask that they be present if there's pets there, most definitely, or emotional support animals. Let me give you guys a little heads up on an emotional support animal thing. And I know somebody's asking me questions about it, and I'm just going to pick one of your names that's asking me questions about emotional. Anna, I'm picking on you. Okay. Anna, I heard that you manage investment property for a living, right? That's what you do. You manage investments. That comes with a very high level of stress. We, as property managers, usually wake up in the middle of the night wanting to know if we handled something properly or addressed something properly. It wakes us up. It's what happens. That is called work-related stress, just so you know. So now that I know your condition, and I know of your need, I am a licensed real estate broker in the state of California. I have the capability of writing that note for you for your emotional support animal the way the law is currently written. It doesn't have to come from a doctor. It doesn't have to come from a therapist. It can come from a professional in the industry aware of their need and their disability. Got it? Okay. Remember, ADA is a very big bear with very big teeth. And I'm starting to hear some legislation go on about emotional support animals. I think that they realized they gave the people the power, and now the people ran rapid with it. And now they're going to try to do something to get that back under control. But I'm telling you right now, that's not your battle, not your war, and you don't want to fight it. That's going to be expensive, okay? Costly. I mean, you're going up against the American Disabilities Act. I hope you have a big wallet. So you want to be very careful. Where can I get a form for a separate parking agreement? It's also advantageous to use a separate storage space agreement so that these are not subject to rent control. Lee, you must have been sitting in my agro class a few minutes ago when we discussed this. Definitely, if you're renting garage space separately from renting a property, you're most likely going to want to use a license agreement and not a landlord-tenant agreement. Basically, you're giving them a license to park there. If you use a landlord-tenant agreement for something, then landlord-tenant laws apply. So you may want to use a licensing agreement. I strongly recommend that you contact your legal counsel. In the event that you don't have legal counsel that can help assist you with that, I would contact Fast Eviction Service. I worked there for 5 years. I'm still very much involved with them. But I would call and talk to the attorneys there. Actually, I would talk to Joel, to be very specific. Ask to speak to Joel, tell him that you talked to Patty and you need to talk about licensing agreement for parking, okay? And he will help answer questions, direct you down the road you need to go to. If you guys need that number, it's, hold on, don't shoot me. It's 1-8. No, I just used the 909 number. So forget the 866 number. 909-889-2000 and ask for Joel. Joel, he's the senior paralegal and very much involved with licensing agreements versus landlord-tenant litigation. So that should help answer that question. Let me see, I got another. Anna, can I have them sign a pet agreement? You don't want them to sign a pet agreement, Anna. It's not a pet. See how that worked? You want them to sign a request for reasonable accommodations as to why you're allowing an animal into the property without the rules of it being a pet. Okay. So a request for reasonable accommodations to make a change on their disability is what's going to protect you from the fair housing discriminatory lawsuit of why you changed the rules for that person. And don't call it a pet, whatever you do. It's an animal. It's an emotional support animal, a therapy animal, a service animal. It's not a pet. Pets have no rules. Pets have all the rules and restrictions because you get to make them. You can charge pet rent, you can charge a deposit, you can charge all kinds of things when it's a pet. If it's not a pet, you can't charge any of that. So don't refer to it as a pet. And then it's governed by the municipalities. So if the city that you live in has a leash law, then your city requires that the animal be on a leash. You can't have any rules. Okay? You can follow the city's rules or the county's rules or the state's rules, but you don't want any rules because you don't want to be named in the lawsuit. See how that worked? Okay, let me go back because I saw another question come through. Can I have them sign a pen? Where can I get that type of form? Request for reasonable accommodations. You can contact Fair Housing. They can give it to you for free, not a problem. You can also contact your legal counsel or your apartment association should all have a request for reasonable accommodations. And that's what you need in your file to basically protect you to say, yes, I changed the rules for this person because they gave me this note for the animal to be on the property. And remember that animal, no problem, Anna, anytime. I think I'll do a class and I'll talk to my web guy. Maybe we'll do a class on emotional support animals and all the various changes that can happen with emotional support animals. And maybe we'll try to do that towards the end of this month, just because it's such a hot topic. That and the money. Show me the money. And I'm talking about the COVID money, but yes, most definitely. Emotional support animals, unfortunately, are one of my areas of expertise. So definitely want to make sure everybody's completely educated in that. That's why I came up with a wheelchair analogy, because when you start looking at it as a wheelchair instead of as a pet or an animal on the property, it answers a lot of your questions about rents, deposits, damages. Is the person that has a wheelchair responsible for the damages when they move out of their unit? Absolutely. So is the person with a dog. So it's kind of how that works. Same concept. Don't want to overwhelm anybody with emotional support animals, but everything that happens in waves. And I will tell you guys right now that we're seeing a wave of mold come through again. So just giving you a heads up, we're seeing lots of stuff with mold coming through. David says, my tenant is in a wheelchair and says I cannot pick up her dog's stool when outside. Is that reasonable? No, it's not. She needs to be able to care for that animal, pick up their feces, etc. If she's not able to pick up their feces, then she needs to have someone hired to do that. Okay. And if there's no one that she's hiring to do that, then that's a problem. That's a nuisance. Absolutely. But again, you want to approach it very, very carefully because you're poking at the ADA, American Disabilities Act. You don't want to mess up there. That's going to be expensive and it's going to hurt. So definitely want to get the assistance of your legal counsel, but that animal that they have on the property cannot be a nuisance and they have to clean up after it. Let's chat about multiple animals. Many of our tenants are collecting animals and not paying a pet deposit or pet-free rent. I've left this alone for COVID, but I'm gearing up to serve pet fee notices. Should I wait? No, I wouldn't wait. I'd gear up to do it on July 1st, unauthorized pets. And until they tell you it's an animal, not a whole lot you can do. And contact your city animal control and ask them what the restrictions are. Some cities have in multifamily dwellings that they can't have a pet over 35 pounds. Whatever your city's rule is what your rule is, because you can't have any rules. Okay, but the city can. So you can follow the city's rules of how many pets per household, yada, yada, yada. If they want to go above that amount, they need to get permission from the city. Because ultimately, that's who's going to come after you as the landlord if the tenant's in violation. They don't give the tenant a notice, they come after you. So you have to follow your municipality's rules and regulations. Everybody got that? I know we're getting all into pets today for some reason. Can you run over this pet and animal difference? You can charge for a pet for not an animal. Okay. An animal, a pet is a pet. It's who we have, it's part of our family. And those of us that are responsible pet owners will pay an extra deposit because that pet is our family member. We will pay additional pet rent because that pet is our family member. That's one of the differences. If you have somebody that is saying, well, yes, it's a pet and I'll pay the additional deposit, the additional rent, that should tell you that that's a responsible pet owner and you want that relationship. Can you charge rent? Absolutely. Can you charge rent monthly for that pet? Absolutely. Can you ask for an additional deposit? Absolutely. What you can't do is if they say it's an emotional support animal, a therapy animal, a service animal. See how that all has the word animal behind it and not pet? That's where you make the difference. And if somebody says, I have an emotional support pet, you can almost guarantee they have no idea what they're talking about. Okay, a pet is a pet. There are no rules or restrictions regarding pets. You can only want pink poodles that are papered as your pets, then that's what your pet rule is. You can make the rules when it comes to pets. Whatever the rules are, you can make them because there aren't any. When it comes to emotional support animals, therapy animals, service animal is a guide dog of America leading the blind. No charges, no nothing, can't do anything. Okay. As far as hedgehogs and peacocks and birds of flight, I saw somebody mention that earlier. Remember, that has to do with the airlines, not housing. That does not apply to you. You have to allow it all. If it's okay by Fish and Game and it's okay by federal wildlife, you have to allow it. Okay? Just so you understand. If a cuffed animal bites someone on the property, who's liable? The owner of that animal, and ultimately the owner of the property. So the owner of that animal becomes liable. If it bites someone on the property, you can most definitely get rid of that animal by serving that 3-day curable breach of covenant to exchange it for an animal that isn't aggressive. This is an emotional support animal, so it can't lunge, bite, bark, strike. And remember, we're talking, it could be any kind of animal, so it can't kick. It could be a horse. It can't be out kicking people. It could be a tiger, so it can't maul people. I'm just saying. So keep that in mind. And I will do a much detailed class, probably, let's do it on the 31st. We'll do it on emotional support animals so that we're answering all the questions regarding them because there's a lot of moving parts there. But mark my words, in the next 2 years, if I had to guess, and I'll throw in 5 years just to cover myself, we're going to see some changes in legislation regarding emotional support animals, therapy animals, etc. They are going to start regulating. They may build a national database. I don't know, but there's already talks of putting some things in the works to put an end to this wild, wild west stuff that's going on, because right now it's a free for all. I mean, let's just call it what it is. I see another question. Is 11-month lease the most effective for new tenants under rent control? If the tenant asks why 11 months, what's a good response? A lot of people under the statewide rent control, so we're talking about AB 1482, they're putting them in on a 3-month term to start and then going month to month thereafter. Some of them do a 6-month term to start and then a month to month thereafter. Some of them are just doing month to month. We're not seeing a whole lot of terms unless it's mandated by a city that requires it. Some cities require that tenants are put in a term. I know Santa Monica is one of them, and I believe West Hollywood is another one of them. So some cities require a term. Again, your municipality would control here, and that would notify us as to the term of the tenancy. The reason why a lot of them are going more into detail in regards to month to month versus the term is if you put someone on a term and you're under 1482, you're signing up to pay the relocation fees when they move out. So a lot of landlords are putting them in on a month to month, and if they're not liking them or it's not working out at month 11, they're just giving them a 30-day notice to vacate, and then they don't have to pay those relocation fees of 1 month under AB 1482, which is the statewide rent control initiative. I hope that answers your question. Can you please tell me more about mold issues? I just, I'm not mold certified, just so we're clear. There is no certification for being mold certified other than being a hygienist. So when your tenant comes to you and they say, I'm mold certified, you can already know they have no idea what they're talking about because there is no certification for mold. Okay, so that makes it one tricky. The reason that I brought up mold earlier is we see things in waves come through the law firm. So in the past 3 months, I've seen an increase in mold issues going on. Maybe it has to do with the weather that we're having. It's just, it could be a trend. I don't know, but I try to give you guys a heads up when I start seeing something coming your direction or potentially coming your direction. So we're seeing a lot more activity with active mold cases and mold problems. The issue about the mold is basically we want to make sure that we're not charging tenants rent until it's eradicated. That's the biggest problem people don't understand is you have a responsibility to react upon notification. And if you do have a mold problem, call me. I'll walk you through the process. We need to be extremely diligent, have a chain of events. Mold is something that is heavily litigated and can be extremely expensive as far as the tenant goes. And I try to keep that a very open, even playing field. I try to jump knee deep into the fire pit, if you will, and let them know. And I'll give you guys a couple of examples and then I'm going to answer the next question. As soon as a tenant, I had a tenant once, they told me, we have mold under our kitchen sink, and they had just moved in. And I said, you have mold under your kitchen sink? And he goes, yeah, my wife's highly allergic to mold. And I said, oh, is she allergic to yogurt? No. Is she allergic to cheese? No. Is she allergic to penicillin? No. Why are you asking? I'm just curious because those are all types of mold. So I just wondered to what extent her mold allergy is. See how that worked? So I downplayed the situation from hello right away. And I let them know being sick and having respiratory failure and being on a ventilator in the hospital, two totally different things. Usually people that have a problem with mold have an allergy to it is why. And that causes respiratory distress. Doesn't mean you're going to get a cold. Okay. We all get colds. It means you have respiratory distress. You can't breathe. You can't catch your breath. You're going to the hospital. Okay. No joke. That would be symptoms of mold. But all tenants want to tell you, oh, I'm sick. I'm sick. Well, it's not the flu. It's not COVID. It's mold. And we could both, any one of us could walk into a property and be standing side by side, and I could be perfectly fine and you could be gasping for air. Maybe you have a sensitivity to it and I don't. It's individual people that get affected by it. Okay, so there's your mold, and I'll get more into that if we need to. I emailed a tenant about leaving. We understand she had COVID. We want to sell this house after she leaves. What requirements, if any, do we have to sanitize for COVID? I was worried about potential disclosure issues. There are none at this time. There are no restrictions regarding disclosures of COVID or telling people about COVID. And the reality of it is COVID is everywhere. It's on your gas pump. It's at your ATM. It's everywhere. So for them to prove that they got it specifically from one particular place is going to be extremely difficult for them to do because it's everywhere. So at this point, there are no requirements for you to prepare that unit. For the next person, technically, in all fairness, in 14 days, that should be dormant anyway. And I wouldn't worry about disclosing anything. Think about it like AIDS. We can't tell people somebody else's personal experience. It has to do with HIPAA law. So the best thing you can do is just shush. Don't say nothing. Okay. You understand she had COVID. We want to sell this house after she leaves. I don't know what city you're in, Val, but I'd list the house for sale now. Once you have an open escrow, you can serve a 30-day notice to terminate tenancy if the buyer intends on occupying the premises. And it's actually the only way you can terminate tenancy, or one of the only ways that you can terminate tenancy right now with the COVID pandemic. So you can't tell them, hey, I want to sell my house. You got to go. Especially in LA County, it's not a cause for eviction at this point, and we have a lot of restrictions because of COVID. So one of the things that you can do while COVID is going on is go ahead and list the property for sale. In the event the tenant doesn't, or you have an open escrow, you can then serve a 30-day notice to terminate tenancy that the buyer intends to occupy the premises. That has to be written right on the notice in order for it to have enough teeth to actually go forth with an eviction. And just so you guys know, everybody's like, oh, we'll just evict them. We'll just evict them. Here's some things you guys need to know and think about, okay? And just saying. In LA County, right now, it is taking 6 months for an uncontested eviction. So if the tenant's not fighting you, they're not doing anything, 6 months in LA County. In other counties, we're seeing that go about 3 to 4 months. So San Bernardino County, Riverside County, we're seeing uncontested evictions taking 3 to 4 months. That has to do with the courts being so inundated and the short staffing because of COVID, and the fact that we're not supposed to be evicted, whatever, blah, blah, blah. But the courts are inundated right now. So if you're looking at eviction, please look at the timeline for that eviction, because you're not going to get any rent during that period. So you're bleeding money. Okay. You're spending money on legal counsel. Just saying. So as far as that goes, if you really need the tenant out of the property, you may want to consider cash for keys. Also, I'd like to bring something to your attention. Some of us landlords aren't putting our properties back on the market right away. We'd rather wait the 3 months until July and then put it on the market so that we don't take the risk of putting in a tenant that's going to cry COVID and then we don't get rent for 3 months. Okay. So a lot of owners right now that have vacancies aren't putting them back on the market, especially when we're looking at single family residences. They're concerned, they're afraid, they're scared, they're holding their property. I get it. But it makes it extremely difficult for that tenant you're trying to get out of your unit because there's nowhere for them to go. If you want to see what I'm talking about, try looking up a 3-bedroom, 2-bath for rent in your neighborhood. Not an apartment, I'm talking about a house. Then you can kind of understand, hey, there really is nowhere for them to go. They're not lying. I mean, go look. I encourage you, know what's happening in your community and around your community, because it affects your rental value and your market rent. So you want to keep abreast to what's going on. You want to watch what other people are renting for. It's how you stay current in the market. Okay. But look around out there. Pay attention. When they come back and tell you, I've looked, there's nowhere for me to go, they're not lying. So here comes my theory. If we offer them enough money in cash for keys, they may go relocate temporarily with family members to get out of your unit because they want the money. See how that worked? So we're seeing a lot more cash for keys offers come out. They're for higher dollar amounts. We're seeing $5,000, $10,000 and up. Just so you know. And for those of you that are currently dealing with court cases in LA County, please Don't panic and freak out and have a massive heart attack when Basta comes to you with their first settlement agreement. Because of COVID, their first initial offer to make the eviction stop and the tenant to get out is usually at about $150,000. Okay. It's just their first offer. Don't panic. Okay. Had somebody call me, I almost had a heart attack today. They want 150,000. It's a tactic. It's a tactic. Okay. Don't panic. Don't lose sleep over it. All right, let me see what another question is. Tenant complains about mold after 6 months of move-in. Is the tenant responsible for curing it? Absolutely not. Landlord's responsible for curing it. I would contact PRC and send them out there. They'll do a free estimate for you on that mold and help you eradicate it or tell you if it's due to poor housekeeping or improper use of ventilation, because those two fall on the tenant. The rest of it falls on you. Okay, got that? Improper use of ventilation or improper housekeeping, if those are the causes of the infestation, all of what it took to eradicate that could fall back on the expense of the tenant. Just so you know. If a okay, hold on, I got more. Her husband just died in the hospital. We're not kicking her out. She's just moving to assisted living. Then she's moving on her own. You didn't ask her to leave. So you're fine. Ignore what I said. I'm just trying to help people that are not in a situation where the tenant is voluntarily vacating. Okay. If a comfort animal is a cat, is the tenant allowed to let the cat eat, drink, and roam around the property when they feel like it, letting it go outside unattended? That's a good question. And I don't know that I have the answer for that, because an emotional support animal would be an indoor animal for the most part, not something that's running around your yard. Just saying. And I get what you're saying. If they're saying that that emotional support animal is a cat and they let it eat, drink, and roam around the property wherever they want to, and it's going outside unattended, I'm assuming that it's going to the bathroom outside unattended. That's where the nuisance comes in. Okay. So if it's going outside, if it's going potty outside and nobody's cleaning it up, that's where your nuisance comes in. Okay. That's where the cure or quit notice comes, to clean up after the emotional support animal. You guys got me? Okay. Got to clean up after it. Okay. I saw another one. Let me see. Me and questions today. You guys are awesome. Thank you. What are good safety precautions to prevent homeless from entering a single family residence while it's vacant? My next door neighbor has a vacant single family residence rental. Homeless family entered through side gate and broke the rear window. What can I do? She's frightened. Next door neighbor, what are the best practices to prevent this? Is there a special lock I could put on, a wood gate, and still allow the gardener access? Check your property often. It's going to depend on what city it's in. And while I'm talking, if you could just type what city it's in, it's going to help me tremendously. There's a lot of issues going on right now because of the COVID pandemic. Okay. And just hear me out, the government says, or our municipalities say, okay, that it is literally impossible for a landlord to evict for unauthorized occupants because of COVID. If those people that moved in with them were going to be homeless because of the COVID pandemic, then they have to allow them to come in with no penalties until after the pandemic passes. See how that worked? So we want to be very, very careful. In San Diego, thank you, because that tells me you're not in the county of Los Angeles and all that bullshit doesn't linger over you. So if you have somebody that enters the property illegally, you would call the police. And I hope everybody is paying attention right now. You want to take notes on the words coming out of my mouth. Okay. You call the police and you tell them that you need them ejected for trespassing. They are going to then tell you that this is a civil matter. and that tenant is a victim because they paid someone to move in here and they're the victim. What you then tell the officer is you are the victim here. That is not your rental agreement, and you agree that it's a civil matter between the tenant and whoever gave them that notice. But for the time being, they are trespassing on your property and you want them ejected. Please take note, I am not saying evicted. Evicted is a civil matter and has happened in a court of law, and the cops don't want to touch that. They don't have to. It's a civil matter. They get to hit the easy button. This isn't a civil matter. Actually, it is a civil matter between the person in the property and whoever gave them that contract and took their money. I am the victim here. They're squatting in my property. They're trespassing. Don't use the word squatting. My bad. They are trespassing in my property and I want them ejected. If they don't fly, then tell them that you want to speak to their desk sergeant or their watch commander. And you plead the same case. Yes, I agree. This is a civil matter for that person that's at the property and whoever gave them that agreement, but I am the victim and I want them ejected. Let me know how that works out for you guys. Everybody got that? Don't use the word evicted. Agree with them that it's a civil matter between them and whoever gave them the contract. That wasn't you, and you're the victim, and you want them ejected for trespassing. Okay? It's worth a shot. And the reason I'm giving you very specific language and very specific is if you can make that work, you avoid the whole eviction process. Hit the easy button, pass go, and get your $200, okay? If you can't, you're going to have to evict and go through the eviction process. Sorry, it's worth a shot. It's worth a good shot. Stand your ground, be very adamant and very understanding. Just saying. Does that hold in Los Angeles? It can, just not during COVID. Okay? Not during COVID. That's the biggest thing. During COVID, it's most likely not going to work because they're going to say, well, you know, it was either be homeless on the streets or come here. And so we came here and here we are. They're not going to throw them out on the street with the COVID pandemic going on. They can't. Okay. Hire the leg breaker. I like you, Val. We're going to get along great. It's like, just shoot them. I'm kidding. Don't do that. Are we responsible for mold around the tub tile and walls? It depends. Is it coming through the back paneling of the wall or is it improper housekeeping? You don't get to determine that, Anna. You hire a professional like PRC Restoration Company, and they will go out and do a free estimate for you, and they will tell you whether this is mold caused from improper use of ventilation, if it's surface mold caused by improper housekeeping, and that's what determines. You don't get to determine. You're not the expert in the field. Get the expert in the field to determine, then you can charge accordingly. Got that, Anna? You have no power here, but per person you hire, the professional in the industry does have the power to say whose fault the problem is and who this falls on. And I hope that makes sense to you. If you need to call me, but are you responsible for mold, or you're responsible for all the mold at hello? You have to eradicate it. But if it's because of the tenant, you can charge it back to them, okay? Hire Larry the leg breaker. I need Larry's phone number, Val. I'm just kidding. So what if the homeless person returns and trespasses again after being ejected? Eject them again. And Lee, I'm going to give you a solid, okay? And oh, I can't give you the number right now. I'm on my phone and I don't know how that would work. You can call Chris with Skyguard Security Services. He does patrol, he sets up cameras, they do live feed video camera. So there's somebody sitting there watching and they're going, hey, and they're talking to him through the camera. Hey, you in the green shirt, what unit are you with? Who are you here visiting? Why did you park in that spot? They can communicate with them through the camera system. I talked to Chris over at Skyguard Security Services. If you guys need his number, text me at 855-WIDGET5. That's my phone number. And I would be more than happy to give you Chris over at Skyguard. He is located in San Diego, So it should be relatively close and an easy process. And he offers a lot of services. He will help go do an inspection for you, acts as a mutual third party between the two, and then reports everything back to you. So he's great. There, Chris, you just got a free plug from Patty. Would you be able to arrange a whole hour on mold issues one day? And can you buy insurance for mold? Yes, I'm going to talk to Hootie, my web guy that does all my web stuff, and see if we can't do a class on mold on the 31st. And I'll see if PRC will actually come and talk with us. And we'll talk about mold and what they do and what they offer. And we'll do that on the 31st of this month. I listen to you guys. When you guys come tell me, hey, I want to know more about this subject, I want to know more about that subject, that's what I need so that I can help you better. So I don't know if we should do it on mold or emotional support animals. You guys tell me down at the bottom what you want to hear more about, emotional support animals or mold, and I will make that happen. That's how that'll work. Moldy animals. Okay, Val, we could do that. I'm just so you know, and I'm not trying to be funny. That's how you get the toxic mold that kills people, is you get, and let me just share a little bit of knowledge with you. The toxic mold that kills people or people are heavily affected by are usually caused by a decaying carcass. So if you have a dead rat in the wall, okay, I'm just saying, and there's a mold issue, it's the mold that grows off of that decaying carcass that causes that toxic mold that people talk about, just so you guys know. So moldy animals was damn funny. Because it's moldy animals that cause that toxic mold. Yeah. And if I'm going to do a class on mold, I definitely want PRC Restoration Company involved, just because they're epic. Let me say this. For me to promote a company speaks volumes. Okay. And the reason that I'm saying that is I've dealt with the cream of the crap out there, you guys. I know those fly-by-night ambulance chasing fire. I've seen it all, okay? PRC is a company that I use them personally. Have used them twice now. They give a free estimate. They give a cause. They walk you through. They hold your hand. They'll talk to your insurance company directly so that you don't say the wrong thing and get the claim denied. They're epic, okay? Epic, just saying. They do a great, great, great job, and I've never had a problem with them discussing anything with the tenant. They're extremely professional. They report back to you. They set up proper containment. I mean, I could go on and on about everything that they do right. I'm telling you, if I recommend a company, I think very highly of them. And that's just me talking to you. Most importantly, when you're talking to somebody, learn who not to call, because that's even more important. Just saying. Who not to call is priceless. All right, let me see if I have another question. If I not, I'm going to open it up for questions. I would like to get emotional support animals or pets an hour to do on the 31st. So it's like people want pets and they want animals. So we're going to do a thing. Who wants what? Maybe we'll do moldy animals. I mean, hey, crazier things have happened, right? All right. Does anybody have any questions? You guys can unmute yourselves accordingly and ask those questions if you choose. I want to make sure everybody's getting the information that they need about everything that they need.
Can black mold grow under your sink or other places without a dead animal being the culprit?
Okay, the difference was toxic mold versus black mold. Black mold is everywhere. It might not even be mold. It could be mildew. Okay. So don't fear that toxic mold. I mean, it's got to have something decaying for that to go that direction. They're few and far between. Okay, most mold cases that I've dealt with, I would say probably 75% of them are tenant caused. Unreported leak under the kitchen sink turned into mold. Why was it unreported? Because the tenant doesn't do the dishes. They use the dishwasher and they never open it under there. That's their problem, not yours. That's unreported tenant caused damage, most likely. There's always a way, as long as we have all the information, that we're most likely going to be able to flip that around. As far as getting yourself protected, as far as insurance goes, talk to your insurance company. Make sure you have mold coverage on your policy for that particular property. That's going to help you. Make sure your tenants have renter's insurance in the event they need to be relocated. That is going to help you. Makes your life much easier, I promise. Hang on, I saw another question come through. Make sure landlords provide a mold form when they move in. Absolutely, a mold disclosure. Basically, and I'll give it to you in a nutshell of what I tell people when they're signing that mold disclosure, is there's no known mold in this house. You're not allowed to grow mold, so no science projects in the refrigerator or anything like that. If you think you have mold, it's a good way to get me out here real quick, flaming like my hair's on fire, so that we can address it. So if you have a mold disclosure, what I tell them is there's no known mold in this house and you're not allowed to grow mold. So no science experiments. And in the event you think you have mold, give us a call and we'll come out here immediately. And what we're doing immediately is trying to determine what kind of mold is this and whose fault is it. You want to make sure your lease contract talks about proper use of ventilation, because that's part of the health and safety code. And I don't know the civil code off the top of my head. I want to say it's 1162. That's not right. No, I don't know it off the top of my head. I know a lot of them off the top of my head. I don't know the one for mold, health and safety, but I could look it up easily if we need it. Let me see what else we got. Do we have is there a good policy for tenants, renters insurance? Here's what I tell them, okay? Geico, Allstate, State Farm, Farmers, they all offer renter's insurance. So what I tell a tenant is whoever you have your auto insurance policy with is most likely who you want to go talk to, because then they get a multi-policy discount and it's much less expensive for them. Just saying. Okay, so what I first do is tell them to contact their auto insurance company. If they still don't have anybody, I recommend Geico, State Farm, Farmers, Allstate. They all offer renter's insurance. Okay, so it's not hard to find, but I immediately tell them to contact their auto insurance because they're most likely going to get a multi-policy discount and it's going to help them having all their stuff in one place. And you always want to be added as an additional insured or interested party on the tenant's policy. That way, in the event that they don't pay, you get notified that their policy is going to be canceled, and things along those lines. That way you can react accordingly. So if you get a notice from the insurance company saying your policy is about to be canceled for non-payment, you would then in turn serve your tenant a 3-day curable breach of covenant because their policy is about to be canceled for non-payment and you know about it. That's what's nice about being listed as additional insured or interested party is you know about it. When things are going to happen, you know. So it gives you the time to react accordingly. How much can I charge a tenant if they put dents and chips in a new appliance and it looks bad now? Dents and chips. I'd have to see the photographs of the before and after. And if you replace the dents and the chips, then you can charge them. That's how that works. If you don't replace the dents or don't repair the chips, you can't charge them. So when you're doing a disposition of security deposit, you can only charge the tenant for actual expenses that you incur. Okay, something to think about. Let me go back. Would it be good to wait until April 2nd in order to collect April rent to request the tenant participate in the California Rental Rent Assistance Program? What if the tenant doesn't want to sign any documents out of fear? Can the landlord still apply for the state? The landlord can apply through the state. I encourage you guys to all do that now because it's first come, first serve. That's at a website called housingiskey.com. The tenant does also need to apply, and this is going to have to do with your approach. Everybody got that? So here's how I would approach a tenant. Hey, I'm just here today, and I do this in person, face to face. Hey, I'm just here today to talk to you briefly and let you know what's going on. The landlord has applied for the rent relief program to have 80% of your rents paid to them and the other 20% forgiven. So it would wipe your slate clean and we'd be starting over fresh. These funds are supposed to cover from the pandemic period through the end of June. So it would give you a fresh, clean slate all the way to June, and then we'd start off fresh on July 1st. So this is going to pay all your back debt, and this is how you go and apply. And the landlord's already applied, so now we're encouraging you to apply to have all of your past due rents wiped out. Anybody that's not willing to run with their hair on fire to sign up for that isn't genuinely having a COVID issue to begin with. You hear me? Does that make sense? The tenant that needs help, that wants that help, that wants that assistance is going to go running with their hair on fire to get it so that they don't get evicted. Simply said. For those tenants that are manipulating the system in their favor, they may not want to apply. Okay? They may not want to apply because they know they don't qualify and they've been scamming the landlord the entire time. In the event that happens and they say, oh, I'm not participating in a government program or blah, 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 blah. Remember, this is the government. They can't discriminate. They can't say you're an illegal immigrant, so we're not going to help you. This is the government. They have laws here protecting immigrants. They're protected. They're a protected class in the state of California. Okay? So remind them that this is just going to pay your rent and wipe everything clean so that we can continue on with our tenancy and our relationship. I'm here to help you. So you want to encourage them. Your approach is everything. And for the most part, you're going to see tenants willing to do that. I saw April added, the landlord can apply, but if the tenant doesn't apply, then it's not going to go anywhere most likely. At that point, I would start an eviction for non-payment of rent. Some tenants are afraid to apply because they think they have to pay it back. Let them know that no, they don't have to pay it back. And all the fine print definitely tells them that they don't have to pay it back. And it's going to forgive that 20% that the landlord didn't get paid. You can never ask for that money. Don't even think about it. Don't even try. Okay. Remember, there's a lot of protections for tenants for retaliatory issues throughout this pandemic. So we can't even talk about it to other landlords 5 years from now. Oh, they didn't pay me during COVID. They're protected. You guys got to keep your mouth shut. That's going to get you sued. And the fines for that is atrocious. So be careful with what comes out of your mouth when somebody's inquiring about rents paid during COVID. What I would say is it was a global pandemic and it affected the whole planet. We don't talk about what happened during that time period. What else can I answer for you today? I mean, shift and manipulate, you guys, but don't let anything come out of your mouth about rents that were or were not paid during the pandemic. The tenant is protected. They're affected, they're protected, and we were all affected, every single one of us. I saw another one. Would applying make a Section 8 tenant look bad in the eyes of Section 8? Absolutely not. No. The tenant can't pay their portion. They can't pay their portion because they were affected by the pandemic. Maybe they lost their child care. Maybe they had to become a stay-at-home teacher. I mean, we've all been affected in various ways. We didn't have to get sick in order to be affected. Just saying. Okay. So keep that in mind. And for the most part, tenants want this debt to go away. For the most part, tenants want to be current on their rent. They want to continue to live there. So it's all going to happen, like I said, with how you approach it. And tenants don't have to pay it back. And it tells them specifically in there, this is not a loan. This is a handout from the government. And just so all of you understand why, here's the why. Given the numbers that were 78% tenant occupied and 50% of that isn't paying rent, that tells you half the state of California is going to be homeless in the next 6 months if the government doesn't step in and do something. Hence why they're not helping nail salons, they're not helping hair salons, they're helping landlords. Because if the government doesn't step in and do something to help these landlords in the next 6 months, half of the state of California will be homeless. Remember us that are holding onto our properties and don't want to let anybody into them? That's our right. We're going to continue to hold those properties. So as people are getting evicted now, currently, we have people in successful evictions that are getting lockout dates. They're getting locked out. There's nowhere for them to go. See the problem? Okay, so that's why they designed this program to help landlords specifically, is so tenants wouldn't become homeless. Because all of us landlords that can evict as soon as possible and have been evicting as soon as possible, we're succeeding. Okay, so that's why they designed this program, is because if the government doesn't step in and do something, us as landlords are going to put our little mighty foots down and we're going to have a huge problem in this state. I mean, just think about it. If half the state of California gets evicted in the next 6 months, where are they going to live? Not in my house. Bet they're not going to live in yours either. See the problem? So that's why the government stepped in with this 80% program, was to stop all of the evictions that are going on. We have a lot of landlords now that were evicting for non-payment of rent that have ceased that and are going after the state's funds instead. And hear me out, you guys. You have 2 options at this point for a tenant that's delinquent. Okay, you can either apply for the state funds, where they'll give you up to 80% of all the past due amounts on your ledger throughout the COVID pandemic through the month of June, if you forgive 20%. Or the alternative is that 25% of the rent is due on or before June 30th for all the months affecting through the pandemic. And then the 75% becomes due and payable as consumer debt, not as landlord-tenant litigation. So on July 1st, that 75% of that rent becomes consumer debt. You can only get a judgment in small claims court, which is removing the cap amounts and making it unlimited starting August 1st. Okay, now keep following me. So you go to small claims, you file the small claims action for the 75% they still owe you. And now it's consumer debt that is unassignable. What does that mean? It means you, the landlord, have to collect on that debt. You have to get a writ of execution from the sheriff's department and file that writ of execution to garnish wages. You, as the landlord, have to do the wage garnishment. You cannot hire an attorney to do the collection process for you. It's unassignable. You cannot hire a collection agency to collect on that debt. It's unassignable. You, as the landlord, are the one that has to do all of that. I think we'll see a lot of document prep come in from our legal counsel helping us do that. But for the most part, a tenant can file bankruptcy and money's gone. It's going to be extremely difficult to collect on that 75% debt, is what I'm trying to tell you. And the state's bailout for 80% is a much better program than the alternative. I have a feeling that those of us that are doing the 75% a lot of us aren't ever going to see that 75% ever. Just saying. Let me see. I got a couple more questions I'm going to address, and then I'm going to get you guys all out of here, so I'm not calling you all day. When do you think the emergency will be called off? I think that this is going to end as scheduled on June 30th of this year, in the next 3 months. And that as of July 1st, we will go back to business as normal, except for terminating tenancy and increasing rents. If we allow 6 months from the end of the pandemic, they can't possibly scream retaliation at us. It is the best business practice to err on the side of caution. And if that is your intention, then pay attention, because you don't want to do anything until after January 1st of 2022. J-Tour. So this 20% loss of rent is gone forever. No cure. Correct. It's gone. It's forgiven. You're getting 80% of your rents. You're forgiving 20%, and you're done here. They're now up to date and current. They can't have any late fees. They cannot have any rent increases at all during the pandemic. Those are both considered retaliatory issues right now. So make sure you don't have any rent increases, and you absolutely do not have any late fees. Are there any cities where you cannot keep a unit vacant once a tenant leaves? Not that I'm aware of, but there are some things you need to be cautious of. Your insurance company will cancel you if the property is vacant. So things you need to be made aware of, even sitting on your vacant unit and holding on to it. You may find yourself getting in some hot water with your insurance company. They may send you a letter saying that they're not going to renew, or they're going to cancel your policy if it's not occupied within the next 30 days. That's something your insurance company does, not me. And I would talk with your legal counsel about having a unit sitting vacant and for how long it's going to sit vacant and so on and so forth. But for the most part, yeah, people are scared, and I can't say that I blame them. Anybody have anything else? Otherwise, I'm going to end this for today. And thank you guys for joining me. It looks like at the end of the month, we're going to do moldy service animals. I'm kidding. We'll talk on both. We'll address mold, and I'll set up a separate class to do for animals. So we'll set up a class for animals in March, and I'll see if we can actually. We'll do animals at the end of this month on the 31st, and then next month we'll do mold. That way I can get PRC to come in and talk about the services that they offer. And we can touch base with them, make sure we get their contact info. I mean, come on, you guys. Free estimates, and they're 24 hours, an hour response time. So they're amazing. Love them. And they do great classes, training classes as well. Everybody's telling me thank you. So I guess we're going to end this. I'm here, you guys. If you guys need me, I'm always here for you. Call me, text me. Texting works really good. Sorry, I was pretty quiet on Monday. We had a death in the family Monday morning. So I was involved and entrailed with all of that. So I wasn't very, hey, hold on, they're having technical difficulties with the website and the money, and forgive me, you guys, life happened to me on Monday. I'm back to business as normal as of today. So I'm sorry if I didn't get right back to you. It is life, right, girly? Life happened to me. It was my turn. But I'm past that now and completely available. If you guys need anything, you can always shoot me out a text message. That is the easiest, quickest way to get a response from me. You can call me. I'm on the phone quite a bit, I'm sure you can imagine. So sometimes you just leave a message and I call you back. But texting me at 855-WIDGET5 is the fastest way. Add to me who you are and what city the property's in, because that's going to be one of the first questions I ask you when you ask me the question. Am I dealing with rent control? What city is this in? Those are key things I need to know when we're chatting, just so that I could give you the best answer that I have in this little blonde brain of mine. All right, you guys hang in there. I'm gonna go. I'm just looking to make sure that I'm answering everybody's questions and we don't have anything that's unanswered, because I don't like that. All right, you guys have a wonderful rest of your week and a great weekend. And I will see you guys all on Wednesday, the 24th is our next one. Happy St. Patrick's Day. I hope you guys are wearing green. For those of you not wearing green, you must want to be pinched. So enjoy that. You guys have a great day. Thanks so much.